Welcome to the first video in the series of the Spanish regulation of agricultural cooperative, made in the framework of the Erasmus Plus project Cooperformance. This first video is about the cooperative principles. The modern cooperative movement was born in the second half of the 19th century. The Rochdale Society of Equitable Pioneers is often seen as the consumer cooperative that laid the foundation for such organization. Faced with the unworthy working conditions of the factories, it was established on October 28, 1844, when several textile workers met and opened a store of supplies of basic necessities to the public. It was influenced by theories of Robert Owen. The pioneers established a series of internal operating standards from which the Rochdale principles are derived. These principles are the basis of the cooperative principle of the International Cooperative Alliance, ICA. At the ICA Congress held in Manchester in 1995, it adopted the so-called Statement on the Cooperative Identity, in which a definition of cooperative values, and cooperative principles are specified. A cooperative is understood to be an autonomous association of persons united voluntarily to meet their common economic, social, and cultural needs and aspirations through a jointly owned and democratically controlled enterprise. Regarding cooperative values, the ICA indicates that cooperatives are based on the values of self-help, self-responsibility, democracy, equality, equity, and solidarity. In the tradition of their founders, cooperative members believe in the ethical values of honesty, openness, social responsibility, and caring for the other. For their part, the cooperative principles are the guidelines through which cooperatives put their values into practice and constitute the particular feature of these entities. The principles are connected to each other, so if one is not respected, the others suffer. The 7 cooperative principles are voluntary and open membership, democratic member control, member economic participation, autonomy and independence, education, training and information, cooperation among cooperatives, and concern for community. The cooperative principles of the ICA are recognized to a greater or lesser extent by all cooperative laws in the world, either expressly as occurred in Spain, Portugal, or Latin America, or through certain reference to them throughout they are articulated as is happening in Italy, France, or Germany. The cooperative concept contained in cooperative laws are often derived from the combination of cooperative values and principles. For example, the National Law of Cooperatives in its Article 1 defines them as the cooperative is a society constituted by people who are associated under voluntary membership and withdrawal to carry out business activities, aimed at satisfying their needs and economic and social aspirations, with a democratic structure and functioning, in accordance with the principles formulated by the International Cooperative Alliance, in the terms resulting from this law. Principle of voluntary and open membership. This principle is also known as the open door principle because members can voluntarily enter and leave the entity at any time. According to the ICA principle, cooperatives are voluntary organizations open to all persons able to use their service and willing to accept the responsibilities of membership without gender, social, racial, political, or religious discrimination. This principle refers to 2 different things: voluntary membership, which assumes that whoever joins a cooperative does so because they want to and will remain it as long as there is their will, being able to withdraw at any time without having to allege any cause. However, in practice, this right is usually limited temporarily by the laws and by statutory clauses, such as, for example, the possible establishment of a notice period and the statutory imposition of permanent commitments. On the other hand, open membership, which means that anyone who meets the objective requirement to be a member can be a member of the entity. Although the laws allow cooperatives to deny entry to some even if they meet all the requirements is properly justified, which can happen in a small cooperative where the principle of mutual trust between members prevails over the open door principle. As a consequence of this principle, the share capital of these entities is not configured fixed but variable. Principle of democratic member control. The ICA provides that cooperatives are democratic organizations controlled by their members, who actively participate in setting their policies and making decisions. Men and women serving as elected representatives are accountable to the membership. In primary cooperatives, members have equal voting rights, one member, one vote, and cooperatives at other levels are also organized in a democratic manner. This principle implies that its members actively participate in defining the entity's policies and decision-making. In cooperatives, the ideal criterion for shaping the social will is that one member, one vote. But national and regional legislation provides for a limitation of the percentage of votes to different classes of members, and the possibility of establishing a weighted plural vote in certain cases. In any case, the important thing is that the quality of the vote does not prevail according to the investment in the society and the equal treatment of the member. Principle of member economic participation. The ICA defines this principle as one by which members contribute equitably to and democratically control the capital of the cooperative. At least part of the capital is usually the common property of the cooperative. Members usually receive limited compensation, if any, on capital subscribed as a condition of membership. Members allocate surpluses for any or all of the following purposes: developing their cooperative, possibly by setting up reserves, parts of which at least will be investable, benefiting members in proportion to their transaction with the cooperative, and supporting other activities approved by the membership. According to this principle, the members of the cooperative contribute equitably and democratically, control their capital, and the distribution of surpluses to the members is made in proportion to their transaction with the cooperative. Principle of autonomy and independence. The fourth principle refers to the fact that cooperatives are autonomous, self-help organizations controlled by their members. If they enter into agreement with other organizations, including governments, or raise capital from external sources, they do so on terms that ensure democratic control by their members and maintain their cooperative autonomy. This principle collides with the intervention of public administration in cooperatives, especially in relation to the policies to promote cooperatives, which sometimes entail an excess of administrative intervention. But the constitutional mandate contained in the Article 129.2 of the Spanish Constitution, by which the public powers will effectively promote the various forms of participation in the company and will promote, through appropriate legislation, cooperative societies, justify this intervention. Principle of education, training, and information. This principle assumes that cooperatives provide education and training for their members, elected representatives, managers, and employees so they can contribute effectively to the development of their cooperatives. They inform to the general public, particularly young people and opinion leaders, about the nature and benefits of cooperation. In the international sphere of the cooperative, the qualification of managers, workers, and members is intended. In the external sphere, the principle seeks the extension of the cooperative movement. To strengthen this principle, Spanish cooperative laws provide for the creation of the Education and Promotion Fund. This reserve is unsizeable, unreportable, and unavailable. Principle of cooperation among cooperatives. This principle is one whereby cooperatives serve their members most effectively and strengthen the cooperative movement by working together through local, national, regional, and international structure. Cooperative intercooperation has two aspects: economic and representative. The first is related to a broad concept of economic business integration. From highest to lowest level of integration, we find mergers, second-degree cooperatives, cooperative groups, and business unions, consortia, economic interest groups, agreements, and other forms of intercooperative economic collaboration. The second could be the representative intercooperation that refers to cooperative associationism aimed at the defense and political and social promotion of cooperativism. It involves the creation of unions, federations, and confederations of cooperatives. In Spain, at the national level, it is worth mentioning, for example, CEPES, Cooperativa Agroalimentaria de España, or COSETA. Concern for community principle. It is the cooperative principle by which cooperatives work for the sustainable development of their communities through policies approved by their members. Compared to capitalistic companies, for cooperatives, interest in the community or corporate social responsibility prevails naturally. Thank you very much. We look forward to seeing you in the next videos. Welcome to the second video in the series of the Spanish regulation of agricultural cooperatives made in the framework of the Erasmus Plus project Cooperformance. This video deals precisely with the legal framework of agri-food cooperatives. Agricultural sector and farm structure. Agriculture is a strategic sector for the Spanish economy, which contributes great economic, social, territorial, and environmental value, not only because of its own activity, but also because of its connection with other sectors of the economy. Spain stands out as a producer and also exporter of fruits and vegetables, and pork products. The contribution of agriculture to gross domestic product (GDP) in 2019 was 2.2%, and the employment generated by this sector represents around 4% of the total number of employees in Spain. Concerning the distribution of the farms according to their size in hectares, farms with a size of less than 10 hectares account for more than 65% of the total. With regard to the owner of the farms, depending on their age, the percentage of young owners is 8.6%. Owners between 40 and 64 years old are 60%, and owners over 65 years old are 51.3%. Regarding the gender of the owners, 23% of the head of agricultural farms are women. Description of the agricultural cooperative sector. In 2018, in Spain there were 3,669 cooperatives, of which 3,119 are agricultural cooperatives and 479 are cooperative community line exploration. In total, cooperatives bring together more than 1 million producer members and represent a turnover of more than 29,000 million euros and provide more than 111,000 direct workers between permanent and temporary workers. Cooperatives have evolved significantly between 2007 and 2018 in the following aspects. Turnover has increased by 40.7%. Direct employment has grown by 21.5%. The number of cooperatives has decreased -8.2%, keeping the total number of members relatively stable, while the average size of each company has increased 53.2%. This is due to the effect of concentration between cooperatives. 20% of cooperatives turn over for 80% of total Spanish agri-food cooperativism. The average turnover of Spanish cooperative is 8 million euros, while the European Union average is 16 million euros. However, if the data of the cooperative with the highest turnover is checked, in the top 60, the average is 157 million euros and 436 million euros in the top 10. Second-tier cooperatives are of great economic importance in the Spanish agri-food sector. Thus, 42% of first-tier cooperatives participate in second-tier cooperatives. In addition, 130 second-tier cooperatives concentrate 22% of the total turnover with an average turnover of 49 million euros. As far as the geographical distribution of the cooperatives is concerned, the 75% of the cooperatives are located in 6 autonomous communities, which in addition concentrate 78% of the total turnover. The leading autonomous community in terms of both the total number of cooperatives and turnover is Andalusia, which has a total of 22.4% of the Spanish cooperatives and which in turn represent 38% of the turnover. Between 2011 and 2018, exports by the Spanish agri-food cooperatives increased by 71% in terms of turnover in foreign market. In 2018, 31% of the cooperatives exported and generated a value of more than 31% of the total turnover of the cooperatives. As for the most exported type of product, fruits and vegetables stand out. Regulation concerning the agricultural cooperative. In Spain, there are multiple cooperative laws due to the distribution of legislative powers that exists between the autonomous communities and the state, which means that each autonomous community, except the Canary Islands, has its own cooperative law that is applicable to cooperatives that operate mainly in the autonomous community concerned. Additionally, there is a national law on cooperatives that is applicable to those cooperatives that carry out their activity in several autonomous communities, without developing it especially in some of them. Spanish cooperative laws are characterized, compared to other legal systems, by jointly foreseeing the legal regime of cooperatives in general, and later they dedicate a specific article to regulate the peculiarities that agricultural cooperatives present in this case. There is no specific law that regulates a specific type of cooperative, except for credit cooperatives. For example, the current national law, Law 27/1999 of 17 July on cooperatives, regulates in detail the legal corporate regime of cooperative societies, incorporation, economic regime, the rights and obligations of the member, etc. Then it distinguishes between the different types of existing cooperative societies, such as worker cooperatives, consumer and user cooperatives, etc. And this is also where agricultural cooperatives are to be found. This means that there are only one or a few more articles specifically aimed at regulating the particularities of agricultural cooperatives, which appears to be insufficient in many cases. Now we'll look at some of the specialties envisaged for this type of cooperative. Agricultural cooperatives are defined as those that associate the owner of agricultural, livestock, forestry, agriculture, or mixed holding, and their aim is to carry out all kinds of activities and operations aimed at making the best use of the member farms, their elements or components, the cooperative, and the improvement of the agricultural population, and the development of the rural community, as well as to attend to any other purpose or service that is specific to the agricultural, livestock, or forestry activity, or is directly related to them and to their establishment or action in the rural environment. In order to fulfill their purpose, agricultural cooperative societies may carry out the following activities, among others: to acquire, develop, produce, and manufacture by any process for the cooperative or for the holding of its members animals, feeds, fertilizers, plants, seeds, insecticides, material, instruments, machinery, installation, and any other element necessary or convenient for agricultural, food, and rural production and promotion. To preserve, classify, handle, process, transport, distribute, and market, including directly to the consumer, the products from the cooperative's holding, from its members, as well as those acquired from third parties. Acquiring, parceling out, clearing, and improving land for agriculture, stock breeding, or forestry, as well as the construction and operation of the works and installations necessary for the purposes. Any other activities which are necessary or desirable, or which facilitate the economic, technical, occupational, or environmental improvement of the cooperative or to the member holdings. To carry out consumption and service activities for its member and other members of its social and territorial environment, encouraging those activities aimed at the promotion and improvement of the agricultural population and the rural environment. The express incorporation procedure. All cooperative societies are set up by means of a public deed and must be entered in the corresponding register of cooperatives in order to acquire legal personality. As opposed to the ordinary procedure for setting up a cooperative, the Cooperative Act of Catalonia provides for the possibility for agricultural cooperative, in which the number of members does not exceed 10, to be registered by the express procedure, which simplifies and reduces the formalities that have to be carried out before the register of cooperatives of Catalonia in this case. Membership. In contrast to other laws on cooperative, the cooperative laws of Extremadura and La Rioja lay down a special rule as regards the minimum number of members required to set up an agricultural cooperative, requiring at least 5 members. As regards the other laws, the minimum number of members required to form an agricultural cooperative is governed by the general rule, which generally requires a minimum of 3 members. Some rules reduce it to 2 and others raise it to 5. for first-degree cooperative, and two-member, which will necessarily be cooperative in the case of second-degree cooperative. Regarding whom can be a member of an agricultural cooperative, the cooperative laws refers to the holder of any right involving the use or enjoyment of agricultural, livestock, forestry, agriculture, or mixed holding. Furthermore, persons having such holding in shared ownership, which is a frequent situation in the sector, should be included as members. In addition, many laws also expressly admit as full members of this cooperative agricultural processing companies, irrigation communities, water communities, communities of property, the inheritances in abeyance, and civil societies or commercial companies, including cooperatives, which have the same corporate purpose or complementary activity as agricultural cooperative. The activity, participation, and economic contribution of members. About the activity of member, it can be seen what degree of the activity commitment the different laws require of the member. For example, whether they require a commitment to exclusive activity or not, for all or part of the activities carried out by the cooperative. The national laws make no provision in this respect, but the regional laws do. This commitment of the member to exclusive activity corresponding to the company purpose of the entity can be established by the bylaws as requirement for acquiring and retaining the status of member. The bylaws may establish difference in the mandatory contribution to share capital depending on the degree of use of the cooperative service that are real or committed by each member. Likewise, they can provide revolving capital system through which members must make new mandatory contribution to capital based on their cooperative activity. Other member-related issues. Member withdrawal. The notice periods to cause voluntary withdrawal in agricultural cooperatives must be reflected by bylaws, being generally longer than in other types of cooperatives. Thus, for example, in some laws is set at 1 year. The maximum time of permanence established as a limit differs between cooperative laws, although it is generally 5 or 10 years. If the bylaws provide for it, new successive periods of compulsory permanence may be established, in a duration never exceeding 10 years. Generational change and family involvement. The article of association might provide for the form of participation of the member of the family community linked to the member's agricultural holding, including being elected to hold office in the company. In the event that the member who is the owner of an agricultural holding ceases to be such, and provided that the status contemplated, he or she may be replaced as a member of the cooperative, and the person who replaces him or her in that capacity by any legally admissible title may be subrogated to all the rights and obligations contracted by him or her with the cooperative or inherent to his or her participation as a member of the cooperative without the need for transfer. The plural vote. In contrast to the democratic cooperative principle of one member, one vote, plural voting is possible for agricultural cooperative. In other words, the bylaws can choose between a unitary voting system or a weighted voting system. Most of the laws specifically regulate this possibility for agricultural cooperative, while others allow it for any first-degree cooperative regardless of the specific type. The justification for breaking with the principle of one member, one vote is based on the fact that the extreme equality in this area in agricultural cooperative is questionable, because the cooperativized activity carried out by one member may differ greatly from one to another, the contribution of the product for its processing or distribution. This mismatch in the relationship between economic interest and decision-making capacity often affects the degree of commitment of the member and his or her interest in participating in social decisions. Therefore, as a measure to encourage active participation, cooperative laws allow for a plural vote subject to limits. In particular, in agricultural cooperative, the bylaws may provide for the possibility of a weighted plural vote, in proportion to the volume of the member's cooperativized activity, and never according to the volume of contribution to the share capital. However, the limitation of this weighted plural vote vary from one regulation to another. For example, in the national law, it is stipulated that in no case may exceed 5 votes, and no single member may hold more than one-third of the cooperative's total votes. Transaction with non-member third parties. Although cooperatives are generally quite restricted in their transaction with non-member third parties, they have been treated differently in law, allowing them greater flexibility, although limited, in the possibility of carrying out transactions with non-member third parties. Thus, as a general rule, agricultural cooperatives may carry out a volume of transactions with non-member third parties that not exceed 50% of the cooperative's total. Regulation concerning cooperative taxation. In Spain, there is a national law that establishes a special tax treatment for cooperatives. Specifically, this is the Taxation of Cooperatives Act of 1990. Where not expressly provided for in this regulation, the general tax rules for legal persons shall apply to cooperatives. There are two levels of protection. Especially protected cooperatives, such as agricultural cooperatives for example. They enjoy additional benefit because of their activities in a specific sector, the economic capacity of their member, and their closer alignment with the mutualistic principle. In order to be especially protected, they must meet a series of demanding requirements. Protected cooperatives. This would be every cooperative that complies with the principle and provision of the cooperative law and tax law, and involves a lower level of the tax benefits than the previous one. However, they may be cooperatives that are not fiscally protected, either because they have not been set up in accordance with the provision of their own regional law, or because of non-compliance with the requirement of the tax law. The main tax benefits enjoyed by protected cooperatives are: on corporate tax, 20% rate on the taxable income corresponding to cooperative results, lower than the standard rate of 25%, and some freedom to depreciate assets. Other important measures include are adjustment rules, not strictly tax benefits, and can be applied also if tax protection is lost. On corporate operation tax, certain exceptions in transactions such as incorporation, merger, demerger, capital increase, etc. On some local taxes, bonus of 95% of the tax liability. Especially protected cooperatives will enjoy a discount of 50% of the tax liability as an additional benefit in the corporate tax. In priority agricultural cooperative, it is up to 80% of the tax liability. On the other hand, there is a specific accounting standard for cooperatives, Order 3360 of 2010. This standard is compulsory for all cooperatives, and the accounting aspect it regulates completes, modify or adapt the regulation of the General Accounting Plan and the General Accounting Plan for small and medium-sized enterprises. Thank you. We look forward to seeing you in the next videos. Welcome to the third video in the series of the Spanish regulation of agricultural cooperatives made in the framework of the Erasmus Plus project Cooperformance. This video is about the incorporation of cooperative societies. Incorporation Act. Cooperatives are constituted through the elevation of the social contract in a public deed and the registration in the corresponding cooperative registry, at which time they acquire the legal personality. In addition, it is necessary to carry out other procedures such as the request for the negative certification of the company name, the opening of an account in a credit institution in the name of the company for the members to make the disbursement, obtaining the provisional tax ID, etc. In Spain, the usual thing was to require 5 common or ordinary members to form a cooperative, a figure that was reduced to 3 by the national law, which is the criterion followed today by most regional law, although some laws especially require 5 members for this type of cooperative. In second or higher degree cooperative, only 2 cooperatives are required to establish. Historically, a constituent assembly was required, that is, the meeting prior to the creating of the public deed of incorporation of all the founding members in which the bylaws of the cooperatives are approved and the managers who will act on behalf of the cooperative and those who have to constitute the social bodies are appointed. However, currently, to streamline the procedure for the incorporation of cooperatives, some laws, such as the national one, only regulate the foundation by simultaneous appearance of all promoting members before the notary, without the need for a constituent assembly. The deed of constitution. The constitution deed includes the essential elements of the legal business origin of the cooperative. Cooperative laws usually specify the expression that the bylaws of cooperatives must contain, and they are the following: the identity of the grantors, Manifestation of this that they meet the necessary requirement to be member. Willingness to establish a cooperative society and class in question. Accreditation by the grantors of having subscribed the minimum mandatory contribution to the share capital to become a member and of having disbursed it, at least in the proportion required by law. If any, value assigned to non-monetary contribution, stating the registration data if they exist, with detail of those made by the different promoters. The contribution of the member can be of a monetary nature or they can be consist of goods and rights susceptible of economic valuation. In this case, the board of directors must determine its assessment after an expert report from one or more independent experts appointed by said body. Accreditation of the grantor that the total amount of the contribution paid is not less than the minimum share capital established by the bylaws. For national cooperative societies, the principle of full subscription and full disbursement of the minimum capital set in the bylaws operates. The national cooperative law does not establish a minimum figure for share capital, but this must be established in the bylaws. Identification of the people who, once the company is registered, have to occupy the different positions of the first board of directors, that of controller or auditor, and declaration that they are not involved due to any incapacity or provision to perform them. Declaration that there is no other entity with the same name, for which purpose the appropriate accrediting certification used by the Register of Cooperative Society will be presented to the notary. As a preliminary step for the constitution, it must be proven that the company name chosen for the cooperative does not coincide with that of another company already registered. In order to this, the corresponding registry must be requested for the certificate of non-coincidence of the denomination. The bylaws. Apart from these minimum mentions, the deed may include all the agreements and conditions that the promoters deem appropriate to establish, as long as they do not oppose the laws or contradict the shaping principles of the cooperative society. The bylaws. The minimum content that is legally imposed in the bylaws is the following. The name of the company. Applying the general regime of company's name, they may be objective, fantasy names, or that refer to one or more economic activities carried out by the cooperative, and subjective, consisting of the name of one or more members. The name of the company will necessarily include the words Cooperative Society, or this abbreviation S-Corp, and in addition, an express reference to its territorial scope, for example, the case of Sociedad Cooperativa Andaluza, or its abbreviation S-Corp and Social object. Register office. The cooperative society has to establish its register office within the Spanish territory, in the place where it mainly carries out its activity or centralizes its administrative management and direction. The territorial scope of action. The territorial scope of action with the member for the development of cooperative activity must be established because the application of national or regional laws depend on it. The duration of the company. The duration of a cooperative can be determinable, or indefinite. The minimum share capital. Part of the law do not legally set a minimum number of share capital. Another established in a similar way to commercial companies, a minimum legal share capital, generally established at €3,000. The minimum mandatory contribution to share capital to become a member. The form and term of disbursement and the criteria for setting the mandatory contribution to be made by the new members who join the cooperative. The way of accrediting contribution to share capital. Accrual or not of interest from mandatory contribution to share capital. The interest accrued on the contribution is a way to compensate the member for not distributing dividends based on the capital contributed and to encourage the disbursement of voluntary contribution. The classes of member requirement for their admission and voluntary or compulsory withdrawal and applicable regime. In a cooperative, there are mainly cooperative members, common or ordinary, which are those who carry out the cooperative activity, the labor production in agricultural cooperatives, and there may also be other types of members, such as working member or collaborating partners. Rights and duties of the members. Right or reimbursement of the contribution of the member, as well as the system of their transmission. There is the possibility that cooperatives establish enforceable or reimbursable and non-enforceable contribution, the reimbursement of which can be unconditionally refused by the board of directors. Rules of social discipline, classification of offence and sanction, sanctioning procedure and loss of membership. Composition of the board of directors, number of directors, and period of duration in the respective position. Likewise, determination of the number and period of action of the controller are, where appropriate, of the member of the appeal committee. In addition of this minimum mentioned, the members can include in the bylaws the agreement and conditions by deemed appropriate. Likewise, cooperatives can develop their bylaws by means of another document called the internal regulation. To carry out the modification of the bylaws, it will be necessary that, before the celebration of the General Assembly, the proposed modification of the bylaws be made available to the member. The competent body is the General Assembly, except for the change of the register office within the same municipal term that the Board of Directors may decide, which must adopt the resolution by a reinforced majority of two-thirds of the votes present and represented. In certain cases, the members who have not voted in favor of the agreement have the right of separation. Registration of the deed of constitution. The President of the Board of Directors, or the person designated for this purpose in the article of the corporation, may request the registration in the corresponding cooperative registry with a period of generally 1 month from its granting. Once the cooperative society is registered in the corresponding cooperative registry, the society acquires full legal personality. However, for various reasons, a cooperative can operate in traffic without being fully incorporated, encountering cooperatives in constitution and irregular companies. Even exceptionally, there may be defects in its constitution process that cause its invalidity. The Registry of Cooperatives. In Spain, there is a register of cooperatives dependent of the General State Administration and 16 regional ones. The concretion of the cooperative registry in which a cooperative has to be registered is determined by the territorial scope in which it mainly develops cooperative activity with its members. Thank you. We look forward to seeing you in the next videos. Welcome to the fourth video in the series of the Spanish regulation of agricultural cooperatives made in the framework of the Erasmus Plus project Cooperformance. This video is about the legal status of members. Introduction. Being part of a society generates a series of rights and obligations for its members, which make up the legal status of the member. From the analysis of the provision relating to the requirement to be member and those that regulate the procedure for the admission of new members, it must be recognized that the breadth of the open door principle of each cooperative depends mainly on the statutory content when establishing the requirement for being member. Amongst other cooperative laws established for agri-food cooperatives, that membership status may be acquired by owners of agricultural, livestock, or forestry farms, including the owner of these farms under shared ownership, and agrarian transformation societies, irrigation communities, water communities, property communities, and civil or commercial companies that have the same social purpose or complementary activity, may also form part as a full member of its cooperative. The agricultural holding of the member, for whose improvement the agricultural cooperative provides its service and supplies, must be within the territorial scope of the cooperative established by the statute. Types of members. Along with common or ordinary or cooperative member, there may be working members, collaborating partners, associate partners, and inactive members, in addition to probationary member or provisional member. The term collaborating partner includes all types of members who do not participate in the cooperative activity but collaborate with the achievement of the corporate purpose. Regarding the inactive member, the bylaws may provide that the member who stops carrying out the cooperative activity or using its service is authorized by the management body to maintain their social relationship as an inactive member. All cooperative laws allow the existence of purely capitalistic partners, investors, who do not carry out cooperative activity and who only make contributions to the share capital. For these cases, quantitative limits are established on the share capital subscribed by these partners and on the percentage of social votes that they can hold, in order that the control of the cooperative remains in the hands of the ordinary member. Rights and obligations of members. All cooperative laws contain one or more articles that include the rights and minimum obligations of the member, which are completed with additional content provided for in the bylaws and developed where appropriate by internal regulation. Cooperative laws usually include the following obligations: comply with the agreement validly adopted by the social bodies of the cooperative, participate in the cooperative activities carried out by the cooperative for the fulfillment of its corporate purpose in the mandatory minimum amount established in its bylaws. The board of directors, when there is justified causes, may be released the member from said obligation in the amount that is appropriate and according to the circumstances that occur. Keeping secrecy on those matters and data of the cooperative whose disclosure may harm lawful social interests. Assess the position for which they were elected, except for just cause of excuse. Comply with the economic obligation that correspond to it. Do not carry out competitive activities with the business activity carried out by the cooperative unless expressly authorized by the board of directors. The member's liability for corporate debts will be limited to contribution to the share capital that he or she has subscribed, whether or not they are fully paid. Among the rights the member we find: attend, participate in the discussion, formulate proposals according to the statutory regulation, and vote on the proposals that are submitted to them in the General Assembly and other collegiate bodies of which they are part. Although cooperative laws are based on the principle that each member has one vote, plural voting is allowed in certain cases. That is, that a member has more than one vote in the General Assembly. Be a voter and eligible for the position of the corporate bodies. Participate in all the activities of the cooperative, without discrimination. Cooperative returns, if applicable. The update, when appropriate, and the liquidation of the contribution to the social capital, as well as to receive interest for them, if applicable. Voluntary discharge. Receive the necessary information for the exercise of their rights and the fulfillment of their obligation. To the appropriate professional training to carry out their work, the working members. Every member of the cooperative may exercise the right to information under the term provided in the law, in the bylaws, or in the agreement of the General Assembly. Social discipline. In the different laws, the reference to the rules of social discipline is included as a mandatory mention of the bylaws, which must determine with precision the types of misdemeanors that a member may incur, their graduation and prescription, as well as the penalties that are applicable to them and the formalities of the penalty procedure, indicating the possible appeals. Most cooperative laws indicate the specific causes that can generate the suspension or right and limits the rates that can be suspended. Expulsion or exclusion is one of the possible penalties that director can impose on members for committing infractions. Thank you. We look forward to seeing you in the next videos. Welcome to the fifth video in the series of the Spanish regulation of agricultural cooperatives made in the framework of the Erasmus Plus project Cooperformance. This video is about the economic regime of cooperatives. The share capital. Introduction. Cooperatives have two forms of financing. Internal, it usually comes from the contribution made by its member, user, or investor, and from the resources generated by its own business activity, like mandatory reserve fund, voluntary reserve, etc. External, comes from financial entities through credits or loans or commercial credit from clients or suppliers of the cooperative. The share capital of a cooperative society is made up of contribution, mandatory and voluntary, both monetary and non-monetary, either at the time of its constitution or at a later date due to the incorporation of new members or the imposition of new mandatory or voluntary contribution. There is a fixed share capital figure in the bylaws that does not represent the nominal share capital, but rather the minimum share capital of the cooperative, since this is variable. While the capitalistic partner receives a dividend proportional to his contribution to the share capital, the cooperative member receives a cooperative return in proportion to the activity carried out in the cooperative. The contribution of the members. Cooperative share capital is made up mainly of member contribution. The contribution that the member makes to the cooperative can be classified according to different criteria, such as their monetary or non-monetary nature, but the most important distinction is between mandatory and voluntary contribution. Mandatory contributions are those that are mandatory for all members. The bylaws must establish the minimum mandatory contribution to the share capital for each member, and its amounts may be different for the different classes of members or for each member in proportion to the commitment or potential use assumed of the cooperative activity. The General Assembly may agree on the requirement of new mandatory contribution, although in such case the dissatisfied member may withdraw from the cooperative. In the case of the entry of new members, the entity is allowed to establish entry fees and increase the mandatory contribution of new members compared to the old ones. Voluntary contributions are optional or voluntary for the member of the cooperative, so they cannot be required as a condition to be a member of the society. The bylaws must establish whether the mandatory contribution to the share capital entitled the accrual of interest for the disbursed part, and in the case of voluntary contribution, it will be the admission agreement that establishes this remuneration or the procedure to determine it. Regarding the documentation of contribution, the law does not impose any specific form of accreditation. The most common way of documenting the membership position in agri-food cooperatives is through registered titles and registered participation books. For agricultural cooperatives, the member who causes justified withdrawal can transmit his contribution to the share capital to his spouse, ascendant, or descendant, if they are members of acquired such status within a period of 3 months. However, some cooperative laws have gone further in admitting possibility of transferring social contribution to third parties. The right to reimbursement of the contribution made to the share capital implies that if the member leaves the cooperative, with a few exceptions, is entitled to be repaid all or part of what he contributes to the company by way of share capital, without prejudice of what is established for non-refundable contribution. However, the members may lose the capital that he contributes to the capital due to the imputation of losses or in compliance with the obligation contracted by cooperative, so what the member really has is a right to liquidate his contribution. Other contributions and form of financing of the cooperatives. There are other contributions that make up the 3 typical forms of financed cooperative other than contribution to the share capital of the member. Periodic fees are the contributions made by the member to cover the agreed expenses, which might be ordinary expenses or investments to develop the corporate purpose. Entrance fees are the supplementary outlay to the amount set as the minimum mandatory contribution to share capital required of new members of a cooperative in operation to avoid or mitigate the effect of the decrease in the equity member ratio. The economic management must. They are the set of products, funds, or goods of any kind which are delivered by the member for the management by the cooperative in the interest of their member and for the development of cooperative activity. For example, in the delivery of crops by the member or the payment of money for the goods and services that the member or the cooperative receive. Cooperative laws usually regulate the basic aspects of other forms of financing of the cooperative, such as the issuance of bonds, participatory titles, and special participation. The cooperative activity with third parties. As for what and how many operations the cooperative can carry out with third parties, a distinction must be made between preparatory or instrumental acts, in which there is no limit, and acts carried out with no member comparable to cooperative activity. Agri-food cooperatives may develop operations with third parties up to a maximum limit of 50% of the total cooperative activity carried out with their members. The mandatory social funds. Cooperative laws impose the endowment of two mandatory funds, the Mandatory Reserve Fund and the Education and Training Fund. The Mandatory Reserve Fund its purpose is to guarantee, since with the mandatory reserve, losses must be compensated if there are no other available reserves. This fund is normally non-participable. However, some cooperative laws allow partial distributability of the mandatory reserve funds in the event of the member withdrawal. Under national law, the mandatory reserve funds is endowed with the following items: the percentage of cooperative surpluses and extra-cooperative and extraordinary benefits established by the statutes or set by the General Assembly, the deduction of the mandatory contribution to the share capital in the unjustified withdrawal of member, the membership entrance fees, and the result of supply operation, deliveries of products or services in other cooperatives by virtue of intercooperative agreements. The Education and Promotion Fund. This fund is unsociable and irreparable between the members, even in the case of liquidation of the cooperative, and will be used for activities that fulfill any of the following purposes: the training and education of its members and workers in cooperative principles and values, or in a specific matter of the corporate or labor activity and other cooperative activities, the dissemination of cooperativism, as well as the promotion of intercooperative relations, the cultural, professional, and welfare promotion of the local environment or the community in general, as well as the improvement of the quality of life and community development and environmental protection action. They will necessarily be allocated to this fund the percentage of cooperative surpluses or of the result established by the statutes or set by the General Assembly, and the economic penalties imposed by the cooperative to its members. The results of the financial years. Determination of the result. The financial year lasts for 1 year, although instead of coinciding with the calendar year, in the agricultural sphere it is usually altered by statutes, for example from October 1 to September 30. The determination of the cooperative result for the financial year is carried out in accordance with the General Accounting Regulation, also considering as expenses the amount of the goods delivered by the member for the cooperative management, valuation not exceeding the real settlement price, and the amount of the corporate advances to the worker member. The remuneration of the contribution to the share capital, special participation, obligation, creditor credits, and financial investment. Typically, cooperative results from extra-cooperative results and extraordinary results appear in separate accounts. Allocation of funds and application of surpluses. The general guidelines to be followed for the proper application of surpluses are the following. From the positive balance of the profit and loss account, net surplus, the amount destined to offset financial year losses will be deducted. Of the surpluses recorded for the determination of the cooperative result and of the extra-cooperative and extraordinary benefits, when the losses of any nature from previous year have been deducted and before the consideration of corporation tax, 13% of them will be allocated to social funds. Regarding the provision of monetary funds, national law establishes that, as minimum, for surpluses, positive cooperative result, 20% to the mandatory reserve fund and 5% to the education and promotion fund. From the profits, extra-cooperative and extraordinary positive result, 50% to the mandatory reserve fund. After the endowment of funds, the amount to be paid for the corporation tax must be calculated. Once the above provision have been made, we will obtain the available surpluses, which must be applied to all or some of the following purposes. Cooperative returns, which must be awarded in proportion to the operation, service, or activities carried out by each member with the entity. They can be made effective by paying them to the member with a certain period from the approval of the annual accounts, or by adding them to the share capital, increasing the mandatory contribution of the member. Endowment to voluntary reserve funds established by the statutes of the General Assembly, and additional endowment to mandatory reserve funds. And the last, participation of salaried workers in the result of the cooperative. Attribution of losses and member liability for losses. The values must establish the criteria for compensation of losses, being possible to allocate them to a special account for amortization against future positive results with a maximum period of 7 years. Regarding the possible imputation of the losses of the cooperative in the assets of the member, it depends on the applicable national or regional law, since some provide for the limited liability of the member to the contribution to the capital that they have to subscribe it, although regarding the imputation of losses indicate that the amount not compensated with the mandatory and voluntary funds will be attributed to the members in proportion to the operation, service, or activities carried out by each of them, with the cooperative without establishing the limited nature of the responsibility. Other establish the unlimited liability of the member for the losses of the cooperative derived from the cooperative activity, and other only allow the allocation to the members up to the limit of their contribution to capital. Accounting and auditing of accounts. Cooperatives must compulsorily keep a series of books, inventory books and annual accounts, diary book, member registration book, register book of contribution to the share capital, and minute books of the collegiate bodies of the company. They must keep an orderly and adequate accounting for their activity in accordance with the provision of the Commercial Code and accounting regulation, taking into account the specialty provided in Order 3360 of 2010, which approves the standard of accounting aspect of cooperative societies. The annual accounts will be prepared by the board of directors, censored where appropriate by the controller or auditor, approved by the General Assembly, and deposited in the corresponding register of the cooperative. They will be obliged to audit their accounts in the cases provided for the Accounts Audit Law and other laws. Thank you. We look forward to seeing you in the next videos. Welcome to the 6th video in the series of the Spanish regulation of agricultural cooperatives, made in the framework of the Erasmus Plus project Cooperformance. This video is about the General Assembly. Introduction. A distinction must be made between the necessary bodies, which are the management body, the General Assembly, and the controllers, and the optional bodies, such as the Appeal Committee and those other designated in the bylaws. The General Assembly is the sovereign body of the cooperative. The traditional management body is the Board of Directors, which is in charge of the representation and senior management of the cooperative. Although in cooperative with fewer than 10 members, it's possible that the management body is configured by means of a single director. The controller supervises the performance of the management body and the annual account. Competence and classes. Concept and competencies. The General Assembly is a previously convened meeting of members, which decides by majority the matter within its competence included in the agenda, and whose agreements are binding for all members, even non-attendees. The matter whose competence is exclusively entrusted to the Assembly are censorship of corporate management, approval of the annual accounts, management report, application of surpluses or allocation of losses, appointment and revocation of the member of the board of directors, the controllers, the auditors, the liquidators, and, where appropriate, the appeal committee, as well as the amount of the remuneration of the director and liquidator. Modification of the bylaws and approval or modification, where appropriate, of the regulation of the internal regime of the cooperative. Approval of new mandatory contribution, admission of voluntary contribution, updating the value of contribution to the share capital, setting the new contribution of new member, establishing entry or period fees, as well as the interest rate to be paid for contribution to the share capital. Issuance of bonds, participative title, special participation, or other form of financing through the issuance of business securities. Merge, demerge, transformation, dissolution of the company. Any decision that involves a substantial modification according to the bylaws of the economic, social, organizational, or functional structure of the cooperative. Constitution of second-degree cooperatives and cooperative groups, or incorporation of these if they are already constituted. Participation in other forms of economic collaboration provided for in the law. Adhesion to representative entities, as well as their separation. The exercise of a social action of responsibility against the member of the board of directors, the auditor and liquidator, and those derived from a legal or statutory norm. The Assembly may also issue instruction to the management body. Types of assemblies. The laws distinguish two classes of assemblies, ordinary and extraordinary. But in addition, there is a special class of assembly that is called the Assembly of Delegates. The ordinary assembly must be held within the 6 months following the closing date of the financial year to censor the corporate management, approve the annual accounts, and resolve on the application of results, although it's possible to include other matters on the agenda. Therefore, the characteristics of the ordinary assembly is its periodicity and its obligation nature. If the director or controller does not fulfill their obligation in order to the call, any member is entitled to request the call to the competent judge. Any other assembly, not foreseen in the law or in the bylaws, will have the character of extraordinary. The directors may call the assembly whenever they consider it appropriate, and must call it when there are reliable requests by members representing 20% of the share capital, and if provided by the bylaws, at the request of the controller. If the call request is not attended within the established period, the interested parties may contact the commercial court of the cooperative domicile. Finally, the Assembly of Delegates is foreseen for those cooperatives that, either due to the number of members or the dispersion of their centers, or other circumstances, have difficulties for the participation of the member in the assembly. This allows members to elect their representative at preparatory meetings to participate in the Assembly of Delegates. The Assemblies of Delegates are governed by the Constitution and operation rules of the General Assembly, and are optional and statutory in nature. The call for the General Assembly. The competence to convene the General Assembly corresponds to the management body, and the controller must urge the summons to the director, and in the event of their inactivity, they must request the usual summons. The call must be made by means of an announcement at the register office at each of the cooperative's work centers, without prejudice to what the bylaws might establish to be done through an individual and written call. When the cooperative has more than 500 members, the publication must also be made by means of a specific newspaper, widely distributed in the territory where the cooperative carries out its work. The call must be published at least 15 days in advance, to a maximum of 2 months. The prior convocation of the assembly will not be necessary in the case of a universal general assembly, which is one in which all the members of the cooperative are present or represented, and agree unanimously to constitute a universal general assembly, approving all of them the agenda of the meeting. Content. Regarding the content of the call, it might include the identification data of the cooperative, the identity of the calling body, the date, time and place of the meeting, if it is on the first or second call, and the item of the agenda. In the call, reference must be made to the right of the member to request the sending of the document related to the agenda. After the publication of the call, up to 8 days later, the member representing 10% of the capital or the controller might request the inclusion of other items in the agenda. Without being included in the agenda, the Assembly can approve the exercise of a social action or responsibility against the director and its revocation, the censorship of the accounts by members of the cooperative or by external person, or the extension of the session of the Assembly, as well as any other provided in the law. Position of member. The right to information is an essential and non-derogable right that has different manifestations. Thus, the member can assign the documentation made available at the cooperative office, and even request free delivery to their homes. In addition, the member can request clarification in relation to the items of the agenda. Likewise, each member can at any time request information or clarification on the progress of the cooperative, and the management body has to respond within 30 days. The limit of the right to information is that the information requested seriously endangers the interests of the cooperative or is detrimental to social interests, or that the request constitutes repeated obstruction or manifest abuse on the part of the applicants, or that such data must be kept confidential in accordance with the provision of a law. The member can attend personally, or they can also do it through the representative, who can be another member who may not represent more than 2. Representation can also be conferred on a family member when authorized by the bylaws. In the case of legal person members, representation is held by their legal representative. The representation must be conferred in writing and specifically for each assembly. Apart from the member, it's possible that any other person authorized by the statutes or authorized by the assembly may attend. The director may require the presence of a notary when they deem inconvenient, and will be obliged to do so when requested by the member representing 10% of the member and requested 7 days in advance of the assembly. Functioning of the General Assembly. The President and Secretary of the Assembly. The Board of the Presidents of the Assembly will be made up of the President and the Secretary of the Assembly, who will be those of the Board of Directors, or those who designated the bylaws. Or failing that, the Assembly will designate those who should occupy the Presidency. The President is responsible for directing the meeting, as well as maintaining order during the celebration, and ensuring compliance with the law. It is the Secretary's responsibility to draw up the list of attendance and the minutes of the meeting. Quorum and list of attendees. The minimum quorum of attendees required for the assembly to be held is in the first call, more than half of the members must be present or represented, and in the second call, 10% of the social votes or 100 votes, although it is possible that the bylaws set a lower attendance for the second call. The bylaws may even establish that the assembly be constituted on second call regardless of the number of members attending. Some regional laws allow the bylaws to allow the assembly to be held through telematic means. Voting right and majorities. The right to vote of the member is non-derogable and is subject to the general rule of one member, one vote. These rules allow exception in agricultural cooperative, because the bylaw can establish the right to plural vote weighted in proportion to the volume of cooperative activity of the member, which cannot be higher in any case than 5 social votes and without it being able to correspond to a single member more than a third of the total votes of the cooperative. Members may not vote when they are in conflict of interest. The regulation requires that certain legal or statutory majorities be reached so that the agreements can be approved. The general rule is that half plus one of the votes present in favor of the approval of the agreement is necessary. Blank votes and abstention are not counted. However, for certain matters such as the modification of the bylaws, transformation of the company, merge, demerge, dissolution, reactivation, etc., the law requires special majority, requiring the favorable vote of 2/3 of the votes represented and represented. The minutes of the Assembly meeting. The agreements adopted by the Assembly are binding from the moment they are approved, except in those cases in which the registration is constitutive. However, the minutes of the Assembly are important for probative purposes of their existence and to be able to register them, where appropriate, in the Register of Cooperatives. The challenge of the corporate agreements. The challenge of the corporate agreements. The resolutions of the General Assembly are open to challenge if they are contrary to the law, the bylaws, or they harm the corporate interest in favor of one or more members of third parties. Agreements contrary to the law are void. The other eligible agreements are voidable. The challenge of an agreement that has been rescinded or validly replaced by another will not proceed. In the case of voidable agreements, the challenge period is 40 days, counting from the date of the assembly is held, or from the date of the registration in the competent registry in the case of registrable agreements. In the case of null agreements, the challenge period is 1 year, except in the case of agreement contrary to public order, because in this case the challenge period does not expire. Regarding legitimation, any member, director, controller, or appropriate the appeals committee, and any third party with a legitimate interest are entitled to challenge void agreements. For the challenge of voidable agreements, only those members who have objected in the minutes to the approval of the agreement or communicate reliable within the following 48 hours, those absent and those who have been illegitimately deprived of their right to vote are entitled. Thank you. We look forward to seeing you in the next videos. Welcome to the 7th video in the series of the Spanish regulation of agricultural cooperative, made in the framework of the Erasmus Plus project Cooperformance. This video is about the board of director and the controller or intervention. The board of directors. The laws oblige the management body to have the form of a board of directors, unless the cooperative has a number of members equal to or less than 10, in which case it may be managed by a single director. The organization and functioning of the board of directors is not legally regulated in detail, the rules being limited to establishing the minimum or maximum number of directors, the necessary existence of the position of president, vice president, and secretary, etc., leaving the majority from the issues to the bylaws. The appointment of the member of the management body corresponds to the assembly. The possible appointment of non-member directors is normally limited to one-third of the members of the board. The delegation of power within the board is possible as long as is provided for in the bylaws, and does not affect certain matters that are considered non-delegable. The directors are responsible for the damage caused to the company, the member, or third parties, when they carry out an action contrary to the law, the bylaws, or without complying with the duties of the position. The members of the management body that carry out the act or the adopted damaging agreement shall be jointly liable, unless they demonstrate that, having not intervened in its adoption and execution, they were unaware of its existence, or knowing it, they did everything convenient to avoid the damage, or at least they expressly oppose it. In no case will the circumstance that the damaging act or agreement has been adopted, authorized, and ratified by the Assembly exonerate from liability. There are two actions to demand the responsibility of the director: the social liability action, for those cases in which the patrimony damaged by the action of the director is the patrimony of the cooperative, and the direct or individual liability action for when the damaged patrimony is the one of the member of third parties. Social action will be brought firstly by society by prior agreement of the General Assembly. The member may exercise it without the need for prior agreement of the Assembly when, having request is not called, or where the agreement having been called is contrary to the exercise of the action, or the company does not execute the agreement to present the demand in within 1 month. Finally, social creditor may exercise the social action when it has not been exercised by the cooperative or by member, and the patrimony is insufficient for the satisfaction of their credits. For the exercise of an individual liability action, the member or creditors to whom the action of the director has caused damage is legitimized. The controllers. The existence of a cooperative management control and oversight body is common in national and cooperative law. Some Spanish law provide for its existence as mandatory, and others as voluntary. The specific regulation for this body is very scarce, although it also has provision common to the board of directors and controller, regarding the remuneration regime, incompatibilities, disabilities, and prohibition, the rules of conflict of interest and responsibility. The controller are assigned the function of supervising the cooperative, in addition to competence in the matter of convening the assembly and any other provided for it by laws. The laws do not usually specify what the audit function consists of, although it seems limited to the preparation of a report of the annual accounts. The controller will be appointed by a majority vote of the assembly, although the general rule is that they must be members. The election of independent expert is also allowed, without being able to exceed a third of the total number of members. The regulation does not establish a minimum number of controllers, and their number cannot exceed the number of members of the board of directors. The duration of their mandate will be between 3 and 6 years, and they may be re-elected. The position of controller cannot be paid, except in the case of independent expert. They have the same liability regime as the director, except that they are not jointly and severally liable. Other corporate bodies. The system of other corporate bodies is possible, specifically the Appeals Committee and is an optional body whose essential function is the processing and resolution of the appeals that are legally or statutorily attributed to it. It will be made up of at least 3 members elected by the Assembly, and their arguments will be executive and final, although they are open to challenge. The other voluntary consultative body that regulates some cooperative law is the Social Committee, a representative body of the member that has function on information, advice, and consultation of the director in all those aspects that affect the working relationship. Thank you very much. We look forward to seeing you in the next videos. Welcome to the 8th video in the series of the Spanish Regulation of Agricultural Cooperatives made in the framework of the Erasmus Plus project Cooperformance. This video is about the dissolution, liquidation, and termination of a cooperative. Introduction. Although they are often used synonymously, dissolution, liquidation, and termination are terms that refer to different but related things. The dissolution is a legal fact that gives rise to the opening of the liquidation process as a consequence of complying with the cases provided as dissolution causes in the legislation or in the bylaws. The liquidation, for its part, is the phase prior to the termination or reactivation of the cooperative, during which the activity of the company is maintained, but already aimed at undoing the links with third parties and members, so that its subsequent termination is possible. Termination is the last phase of the dissolution process, as a consequence of which society will cease to exist. Dissolution. According to its way of operating, the causes of dissolution can be classified into 3 types: dissolution of right, dissolution by a prior verification of the General Assembly, and voluntary dissolution. The latter will be done by agreement of the General Assembly, adopted by a majority of 2/3 of the members present and represented. On the other hand, the fulfillment of the term established in the bylaws supposes a cause of dissolution of full right, for which, once the term of duration of the cooperative has elapsed, it is dissolved unless it has been expressly extended, and the extension has been registered in the Register of Cooperatives. The other causes of dissolution, with the exception of the one provided for Section D, which does not really constitute a cause of dissolution, require the adoption of the dissolution agreement by the General Assembly. They are as follows: the standstill of the corporate bodies or cooperative activity for 2 years, without just causes, in such a way as to make impossible to function. The reduction of the number of members below the minimum established in the law or of the share capital below the minimum established by statute, without reestablishing them within 1 year. The realization of the corporate purposes or the impossibility of its fulfillment. The merge, absorption, or total demerge. Any other cause established in the law or the bylaws. The General Assembly must be previously convened by the Board of Directors, within a month from when the existence of the cause for dissolution has been verified. Any member can request the Board of Directors to make the call. A simple majority of votes is sufficient for the adoption of the resolution, unless the bylaws require a greater majority. If the Assembly is not convened or it does not reach the dissolution agreement, any interested party might request the judicial dissolution of the cooperative. Failure to comply with the obligation to convene the General Assembly to request judicial dissolution or the declaration of insolvency implies the joint and several liability of the member of the management body for all the corporate debts generated from the month following the cause that justifies the dissolution or declaration of bankruptcy is verified. The dissolution agreement raised to a public debt or, where appropriate, the judicial or administrative resolution will be registered in the corresponding cooperative registry and must be published in one of the most widely circulated newspapers in the province of the register office. Liquidation. Once the company is dissolved, the liquidation period opens, except in cases of merge, absorption, or demerge, where the companies participating in the operation are directly terminated. The dissolved cooperative society retains its legal personality, while the liquidation is carried out, a period in which the expression liquidation must be added to the corporate name. Some regional laws allow that dissolution and liquidation agreements can be adopted in the same General Assembly, and such points must be included in the Assembly agenda, provided that there are also no corporate creditor or that the amount of their debt has been duly guaranteed and the formalities provided for in the laws have been observed. On the other hand, when a dissolution is known by full right and the causes that motivated it have ceased, there is the possibility that the cooperative in liquidation can be reactivated, provided that the reimbursement of the contribution to the members has not begun. The reactivation agreements must be adopted by the General Assembly, by a majority of two-thirds of the votes present or represented. During the liquidation, we find certain peculiarities in the functioning of the corporate body. Liquidator. With the opening of the liquidation phase, the directors cease their position and are replaced in their function by the liquidator. If the bylaw have not provided who is responsible for carrying out the liquidation task, the General Assembly will designate the liquidator, in an odd number from among the members, by a secret ballot and by majority vote. The General Assembly might designate non-member for this function, without in any case being able to exceed one-third of the total. After the appointment of the liquidator, the board of directors will subscribe with them the inventory and balance sheet of the cooperative, referring to the day on which the liquidation begins and before the liquidators begin their operation. Regarding their form of action, if there are 3 or more liquidators, they will act collectively and adopt the resolution by majority. The liquidator will carry out all the operations leading to the liquidation of the entity, rendering accounts of the liquidation progress and the corresponding balance for their approval before the General Assembly. The rules of an election, incapacity or revocation, incompatibility, and responsibility of the member of the management body will be applicable to them. Unless otherwise provided in bylaws, the position of liquidator will be for an indefinite period. The General Assembly. As regards the functioning of the General Assembly body during the liquidation period, its call and meeting will be maintained. It will be called by the liquidator, who will preside over it and will report on the progress of the liquidation. The controller. For the supervision of liquidation operation, a controller may be appointed, and its appointment may be requested by 20% of the social votes to the judge of first instance of the Cooperative Register Office. As for the liquidation operation, they must be carried out within a maximum period of 2 years from the dissolution agreement, unless some justified force majeure prevents it. After this period, any member may request the competent judicial body to remove the liquidator from their position and present a proposal for new appointments. The liquidation procedure basically consists of 2 phases. The first involves the liquidation of the relationship and debts with third parties. Until the cooperative debts has been fully satisfied, they have been consigned or the payment of non-due credits can be ensured, the second phase that involves the adjudication and distribution of the company assets may not proceed. The liquidator will make an inventory and an initial balance of the liquidation, and will proceed to the realization of the corporate assets and the payment of the debts. Whenever possible, they will seek a block sale of the company or organize production unit of the cooperative. The sale of the real estate will be done by public auction, unless the General Assembly expressly approves another valid system. The remainder of the company assets will be adjudicated following the order contemplated in the regulation. First, the amount of the Education and Promotion Fund will be made available to the corresponding federative or associative entity. Secondly, the member will be reimbursed the amount of the contribution to the share capital that they had credited, once the profit or losses corresponding to previous years have been paid or deducted. Thirdly, the member will reimburse the participation in the voluntary reserve funds that are distributable by statutory provision or by agreement of the General Assembly, distributed in accordance with the rules established in the bylaws or in said agreement, and failing that, in proportion to the activities carried out by each of the members with the cooperative during the last 5 years. Finally, if any, the said liquid will be made available to the cooperative society or corresponding federative entity. It is envisaged that any member of the cooperative in liquidation that has a project to join another cooperative may demand that the proportional part of the liquid asset left over from the liquidation be entered into the mandatory reserve fund of the cooperative society to which it joins. Once the liquidation operations are completed, the liquidator must submit for the approval of the General Assembly a final balance, a management report on said operation, and a project for the distribution of the surplus assets, which must be previously censored by the liquidation controller, in the case of having been appointed. The final balance and distribution projects must be published in one of the newspapers with the highest circulation in the province of the Register Office. Said balance sheets and projects may be challenged within a period of 40 days for their publication and in accordance with the procedure established for challenging the General Assembly resolution, by any member who feels aggrieved and by creditor whose credit has not been satisfied or guaranteed. Termination. Once the liquidation is finished, the liquidator will grant a public deed of termination of the cooperative in which it must be stated that the final balance sheet and the asset distribution project have been approved by the General Assembly and published. The period for challenging the agreement has elapsed without any challenge having made or the judgment which decided them has become final, and the corporate assets have been awarded. The final liquidation balance, the asset distribution project and the Assembly certificate of agreement must be included in the public deed. Once the liquidation and distribution of the corporate assets have been completed, the liquidator must request with the deed the cancellation of the company's registry entries. The deed will be registered in the corresponding cooperative registry, where the books and documents related to the cooperative must also be deposited, unless the liquidator assumes the duty of conserving them. Lastly, some regional cooperative laws provide for what happens in the event of debts or assets arising after the cooperative registration is cancelled. In the first case, the former member and collaborator will be jointly and severally liable for unsatisfied corporate debts as to the limit of what they would have received as a liquidation fee. In the event of the merger of an asset, the former liquidator will distribute it as appropriate among the former ordinary member and collaborator. Thank you. We look forward to seeing you in the next videos. Welcome to the ninth video in the series The Spanish Regulation of Agricultural Cooperatives made in the framework of the Erasmus Plus project Cooperformance. This video is about the structural modification of a cooperative. Concept and applicable regulation. Structural modifications are those alterations of the company that go beyond simple statutory modification to affect the patrimonial or personal structure of the company. They are usually used as an instrument for business restructuring, reorganization of a group, transfer of economic units, reorganization of a company and economic difficulties, differentiation of economic activities, etc. Law 3 of 2009 of April 3 on structural modification in commercial companies regulates the transformation, merge, demerge, and global assignment of assets and liabilities. Although the law of structural modification also includes the international transfer of the register office despite not being considered as a structural modification. The aforementioned law regulates this operation in a unitary way for all commercial companies. However, it explicitly leaves cooperative societies out of its legislative scope of application, whose structural modification, as well as the international transfer of the register office, will be governed by their specific legal regime. Thus, for example, to know the regime of a merge or demerge of a cooperative, it will be necessary to attend to which cooperative law, regional or national, is applicable to know how the operation is regulated. It should be taken into account that when dealing with operations involving the participation of cooperative societies from different autonomous communities, the procedure provided for in different cooperative laws must be coordinated. Cooperative laws focuses on the regulation in greater or lesser detail of transformation, merge, and demerge. Some cooperative law also includes the regulation of the global transfer of assets and liabilities. The regulation of this operation is generally weak compared to that provided for in the law of structural modification. Transformation. The transformation implies a change in the social type, maintaining the legal personality, that is, the ownership of rights and obligations and relationship with third parties. It's a structural modification that has traditionally been used the most in practice, either an escape from cooperatives to other types of entities due to the limitation or obligation that the cooperative model presents and due to the loss of feeling of the cooperative spirit of its member, or as a tool to save companies that had difficult economic situation or that did not have generational replacement. And it was the worker through this transformation into a cooperative who had been able to continue with the activity of the company. Transformation of an entity into a cooperative. Any association or society that is not cooperative in nature, an economic interest group, can be transformed into a cooperative society provided that, where appropriate, the requirements of the corresponding sectoral legislation or regulation are met and that the respective member can assume the position of cooperator in relation to the corporate purpose envisaged for the entity resulting from the transformation. Cooperative laws briefly regulate this operation since its principle it will be governed by the regulation of each type of society that is transformed, in addition to the few specialties that cooperative law provides for it. Transformation of a cooperative. Cooperative societies can be transformed into civil or commercial companies of any kind in accordance with the applicable regulation, without the legal personality of the transformed entity being affected in any case. Regarding the effects of the operation, in the first place, the continuity of the participation of the member in the capital of the new entity must be ensured, which must be proportional to the participation they had in the cooperative. Second, the transformation agreement into some type of entity whose debts are personally liable by the member will only take effect with respect to those who have voted in favor of the agreement. And finally, the balance of the mandatory reserve funds, the education funds, and any other form of reserve that are not distributable by statute between the member will receive the intended destination in the case of liquidation of the cooperative. Regarding transformation procedure, national law and some regional ones refer to the regulation of the merge with regard to the condition for the adoption of the transformation agreement by the General Assembly. On the other hand, other regulations such as the Andalusian one do regulate in some detail the adoption of the transformation agreement and everything related to it. Merger. We could define the merger as the concentration operation by which two or more companies are integrated into one, transmitting by universal association the assets of the company that are extinguished and passing their member to the resulting company. Law 13 of 2013 of August 2, promoting the integration of cooperatives and other associative entities of an agri-food nature, created the figure of priority associative entities. To obtain this recognition, the entities that apply for it must be a result of an integration between agri-food cooperatives and other entities, such as the merger. The entities that achieve this qualification will have priority to participate in aid and subsidies from the rural development programs. In addition, to achieve this recognition, they have to meet other requirements, such as being supra-autonomous entities, having a high turnover, etc. Some autonomous communities have provided similar figures within their territory, such as Andalusia, Castilla y León, Castilla-La Mancha, which create the figures of the priority associative entities of an regional nature, and which require a lower turnover than the national version. There are two basic types of merger: merger by absorption and merger by creation of a new company. In the first one, a society absorbs another that is terminated. In the second, two companies are integrated, creating a new company, and the two original companies are terminated. The legal regime of the procedure is common for both cases, although there are certain specialties in terms of the mention that the merger agreement, the public deal, or the information offered to the member when the call is published must contain. Merger by absorption is very common in mergers that occur within a group of companies or when one of the companies is much larger than the other. And on the other hand, the merger by constitution of a new company tends to be more frequent in mergers between companies of similar size. Effects of the merger. Merger produce a number of exceptional effects. First one, termination of the companies participating in the operation. All will be terminated in the case of merger by creation of a new company or those absorbed in the merge by absorption. The second, passing of the member of the participating companies to the resulting or termination of the member. All members will be grouped into a single company, resulting from the merger, except for those who have exercised the right of separation. The passing of the member is carried out through the recognition of each member of the results of the book value of their capital contribution, in the terminated cooperative, increased where appropriate by the value of the distributable reserve. Transfer involved by universal succession of all the assets of the participating companies to the resulting company. The global transfer is absolute, affecting both the member and the third parties who have contracted with the companies that are terminated. The resulting company will assume all the rights and obligations of the terminated company and will be ultimately liable. The funds, whether distributable or non-distributable, will be integrated into those of the same classes. Although the most common is the merger between cooperatives of the same class, the merger between cooperatives of different classes should also be understood as possible, as would be the case of the merger between an agri-food cooperative and a credit cooperative, in which case it would be also necessary to apply the corresponding sectoral regulation. The merger is an imperative procedure that can be divided mainly into four phases: primary or preparatory phase, decision phase, phase of dependency and protection of the satisfied member and creditor, and enforcement phase of the merger. Furthermore, as possible challenge to the merger could be possible. A cooperative in liquidation can participate in a merger before the reimbursement of the share capital contribution to the member has begun, as well as a cooperative in bankruptcy, both as a solution provided in the agreement with creditor as well as the liquidation phase. Preliminary phase. During this first phase of the merger, the board of directors of the different cooperatives carry out the contacts and previous negotiation to set the conditions of the operation. They are in charge of drafting the common merger project, in which the conditions of the operation are generally set out, as well as the director report. They will also have to obtain, where appropriate, a report from independent experts. The director must convene the General Assembly of the respective cooperative. The call serves to make the necessary information about the merger available to the member at the register office and even request free shipping or delivery. Cooperative laws establish the document that must be provided to member. Decision phase. Once the call is made, the General Assembly of each of the participating cooperatives must meet and adopt the agreement by which they approve the merger project, by reinforced majority without making any modification to it. In addition, each assembly must approve the merger balance. Those members who are dissatisfied with the merger must record their opposition to facilitate, where appropriate, their exercise of the right of separation from the cooperative or even challenge the merger agreement. Once the operation is approved by the General Assembly of each of the cooperatives participating in the merger, they are obliged to continue the procedure until the end. The merger agreement of each of the participating cooperatives must be published in the corresponding official gazette and in a newspaper with wide circulation in the province of the register office. Pendency and protection phase. After the approval of the merger agreement and its publication, we enter the pending phase or protective phase, in which the right of the member and third parties must be protected through the possibility of exercising the right of separation by the member or the right of opposition by creditors. With regard to the right of separation, the member dissatisfied with the operation is recognized the possibility of separating or causing justified withdrawal from his/her cooperative. The members who have not voted in favor of the merger will be legitimized. The resulting cooperative will be the one that assumes the obligation to liquidate the contribution to the satisfied member within the term provided for the case of justified withdrawal. As regards the right of opposition of creditors, it protects creditors against the elimination of the need to require the consent of the creditors when there is a change in debtor. Creditors whose credits are not adequately guaranteed are delegitimized. If any creditor exercises this right, the proceedings are suspended. As the problem lies in knowing when a credit is understood to be sufficiently guaranteed, the creditor's criterion to determine that sufficiency seems valid. To avoid problems, it would be advisable to have a joint guarantee provided by a credit institution or even make the payment itself. Enforcement phase. Once the necessary period has elapsed for member and creditor to have been able to exercise their respective rights, the agreement must be executed. For this, the merger agreement adopted by the General Assemblies of the participating cooperatives must be raised to a single public deed and registered in the corresponding registry. With discretion, the effects of the merger take place. And the last one, challenge. As regards the possibility of challenging the merger, no cooperative law provides a specific challenge regime for the merger as it does in the case of Article 47 of the Law on Structural Modification. However, it should be understood that in all cases it is possible to challenge the operation according to the general regime for challenging the corporate resolution, as is provided in the Andalusian law. Other modalities. Heterogeneous merger. We are faced with a heterogeneous merger when entities of different social types merge, for example, a cooperative with a limited company. In these cases, two different laws must be applied. On the one hand, the corresponding cooperative law, national or regional. On the other hand, it will generally be the law on structural modification. The regulation of the absorbing company, or that is established as a result of the merger, will be applied, but respecting at least the rules related to the merger agreements and the right of separation of the member and third-party guarantees, right of opposition of the creditor, provided for in the applicable cooperative law. Regarding the destination of the funds, if the resulting company, the absorbing one, is a cooperative, the social fund remains. On the other hand, if the resulting company is not a cooperative, the Education Promotion Fund and the Mandatory Reserve Fund, or the irrepartible part thereof, as well as any voluntary fund provided by the bylaws that has the character of repartible, will not be integrated into the resulting society, but rather in the destination it will be the same as in the case of liquidation or transformation. Transformation of a cooperative from second to first degree by absorption of its member. A peculiar operation in the field of cooperatives is one that allows a second-degree cooperative to become a first-degree cooperative, for which it is necessary to absorb its member cooperatives. This is a specific case of structural modification of cooperative. This hybrid operation involves carrying out two operations simultaneously in a single act, a merge and a transformation. Other structural modification. Demerger. Demerger could be defined as the operation through which the assets of a company are fully or partially divided, passing to another or other existing or newly created company. Thus its members also become part of the beneficiary companies of the merger. Cooperative laws pay little attention to regulating. The demerger can be total or partial. The procedural term could be roughly like that of a merger. The only specialty is the need for the demerger project, to contain a detailed proposal of the part of the patrimony and the members that are going to be transferred to the resulting or absorbing cooperatives, and the reference to the amount of the mandatory social funds that are going to be transferred to the resulting or absorbing cooperative societies. Along with the right of opposition, we find as a mechanism for the protection of creditors that the cooperative laws contemplate a special regime of liability. If the absence of a compliance by a beneficiary cooperative of an obligation assumed by it by virtue of the demerger, the remaining beneficiary cooperative of the net assets attributed to each of them in the operation will be jointly and severally liable for compliance thereof. If the demerged cooperative has not ceased to exist as a result of the division, the demerged cooperative itself will be liable for the entire obligation. Global transfer of assets and liabilities. The global transfer of assets and liabilities is only regulated in some of the cooperative laws. The global transfer of assets and liabilities is only regulated in some of the cooperative laws. The global transfer of assets and liabilities will be that operation by which a registered company can transmit in block by universal association all its assets to one or more members of third parties, in exchange for a consideration that cannot consist of share, participation, or quotas of members of the transferee. In this regard, the cooperative legislation contemplates that the General Assembly can agree to the global transfer of assets and liabilities to one or more members, to other cooperative societies or third parties, setting in any case the condition of the transfer and adjusting to the provision laws specifically contemplated in the operation and also for the modification of bylaws. Regarding the effects of the operation, the destination of the social funds will be the same as the foreseen with the transformation. On the other hand, at the global asset and liability transfer side, a provision similar to that of the demerge is contemplated, according to which, for the obligation assumed by an assignee that are unfulfilled, the other assignees will be jointly and severally liable, up to the limit of the net assets attributed to each of them in the assignment, and, depending on the case, the member up to the limit of what they would have received as consideration for the assignment, for the company itself that had not been terminated, for the entire obligation. Joint and several liability will prescribe after 5 years, and for the transfer procedure is similar to that of the merger with certain adaptation. Thank you. We look forward to seeing you in the next videos. Welcome to the 10th video in the series of the Spanish regulation of agricultural cooperatives made in the framework of the Erasmus Plus project Cooperformance. This video is about the insolvency proceedings of a cooperative. Applicable regulation. The particularities provided for the cooperative bankruptcy in its own regulatory regulation and in bankruptcy regulation, Royal Legislative Decree 1 of 2020 of May 5, which approves the revised text of the bankruptcy law, are very rare. This does not mean that the cooperative does not present them in practice, due to their special nature and the relationship with members. They simply lack express regulation. Precondition of the insolvency proceedings. There are two. Regarding the subjective precondition, the declaration of bankruptcy proceeds with respect to any debtor, whether natural or legal person, excluding entities that make up the territorial organization of the state, public bodies, and other public law entities that may not be declared in bankruptcy. As regards the objective precondition for a cooperative to be declared bankrupt, it would be necessary that, as a debtor, it is in a situation of insolvency. Insolvency can be current, the debtor cannot regularly fulfill its obligations, or imminent, the debtor anticipates that they will not be able to regularly and punctually fulfill this obligation. In order to determine the system of this insolvency, here we find a special problem related to cooperatives due to the possible consideration made of contribution to the share capital as their own or third-party resources, and also due to the existence of their mandatory funds. Therefore, cooperative societies that are in a state of insolvency can be declared bankrupt, being the bankruptcy law applicable. Bankruptcy application. In principle, the person obliged to request the declaration of the bankruptcy of the cooperative society will be its director, within the 2 months following the date on which they would have known or should have known the current insolvency status of the same. The bankruptcy will be presumed guilty before the breach of its duty and before the breach of the duty of collaboration with the judge of the proceeding and the insolvency administration. As a consequence, director, liquidator, or manager of the cooperative might be sentenced with or without solidarity to the total or partial coverage of the deficit where their conduct would have aggravated the state of insolvency of the entity. As regards the legitimacy to request the declaration of the bankruptcy by the member, in principle they will not be legitimized, unless their personal responsibility for the corporate debts has been established by laws. Cause of dissolution. The opening of the liquidation phase in the bankruptcy of the company is among the causes of dissolution of the cooperatives. The mere declaration of insolvency is not enough for the company to go into dissolution, but it will not take place until the liquidation phase is opened. Specialties of the cooperative in bankruptcy. The application of the bankruptcy procedure to cooperative societies affects certain aspects such as the variability of their share capital by the open doors principle, the different kinds of contribution to share capital and the remuneration, the specificities of the reserve funds and its endowment, the formation of results and its distribution or in the participation of the member in the economic financial flows of the cooperative. Social funds. Cooperative societies have the particularity that the regulation requires the endowment of a series of social funds that in principle have the character of irrepartible, such as the Mandatory Reserve Fund and the Education and Promotion Fund. The Mandatory and Reserve Fund is intended for the consolidation, development, and guarantee of the cooperative. On the other hand, the Education Promotion Fund, whose purpose is the training and education of members and workers, the dissemination of the cooperativism, or the cultural, professional, and welfare promotion of the local or community environment, etc., is unattachable and irreparable between the members, even in the case of liquidation of the cooperative, and its endowment must appear in the liabilities of the balance sheet with preservation of other items. This affects the determination of active mass of the cooperative's bankruptcy, since the assets assigned to the education promotion funds are unattachable, except for debts contracted for the fulfillment of its purposes. Therefore, it cannot be used to compensate the obligation with the creditor and must be separated from the bankruptcy state. The section. Despite the fact that the regulation recognizes management autonomy and separate access to the section, the system of different sections within the cooperative does not result in an exclusion of assets according to the creditor in question, but rather implies an order of priority in terms of order of payment of the credits. Liability of the members. Although in most cases the liability of the cooperative member is limited to the share capital contributed, some cooperative laws contemplate the possibility of statutory provision for the member personal liability. If the responsibility of the member was not limited, the guarantee of the creditors of the cooperative would be greater, since it would have the personal responsibility of the member that would be subsidiary with respect to that of the cooperative itself and jointly with respect to the other member. Share capital as an external resource. The consideration of cooperative share capital as an external resource, according to international accounting regulation, has implications within the proceeding. However, cooperative regulation allows both contribution to the share capital with the right to reimbursement in the event of withdrawal. In principle, they would seem to be assimilated to a creditor since the contributions are considered as liabilities, and contribution with the nature of equity. Their holders are considered as owners. However, regardless whether they are reimbursement or not, the capital contribution continues to be part of the share capital and will be liable for the corporate debts, with the losses of the cooperative being attributable to it. Ownership of funds and assets contributed by member. Regarding the ownership of the funds and assets contributed by the member for the development of the cooperative activity, we must differentiate between different assumptions. In some cases, it will be social contribution in kind, and other occasions, the rights of use and exploitation assigned by the member, for example in cooperatives of community exploitation of the land. In the latter case, as they are only transferred by the member to be managed by the cooperative, it must be understood that the property continues to belong to the member, so it must be separated from the active mass. In the case of non-monetary contribution, there is no assignment or transfer, but the cooperative becomes the owner of the asset or right, so it must be included within the active mass. Payment obligation for cooperative operation. In relation to the payment obligation for cooperative operation with member, if the cooperative activity consists of supplying products from supplier member to the cooperative, it will depend on the case, but in principle the amount of this operation that has not been paid in the amount of declaration of the bankruptcy should be considered included within the passive mass as ordinary credit. Credit by sources of financing and interest of contribution. Funding sources such as obligation, participatory titles, and participation accounts are considered ordinary credits, unless they are considered subordinate if the members are considered as persons especially related to the debtor. The members may receive interest from the contribution to disburse share capital. If they have not yet been received, they will be considered as subordinate credits. The same consideration will be given to the interest derived from the rest of the financing instruments that the cooperative has. Thank you. We look forward to seeing you in the next video. Welcome to the 11th and last video in the series of the Spanish Regulation of Agricultural Cooperative made in the framework of the Erasmus Plus project Cooperformance. This video is about the cooperation among cooperatives. The different forms of cooperation between cooperatives. We can differentiate between three areas of collaboration. The economic aspect, cooperative integration, and which refers to the collaboration to achieve a business purpose, and the political aspect, representation and defense of interests of the cooperative movement through collective action. constitutes movement cooperative or federalism, cooperative associationism. Within cooperative integration can be differentiated to the time between those formulas without and with linking assets. Belong to the first group, no-linkage assets, second-degree cooperative, cooperative group, service cooperative, and other forms of collaboration. The integration formulas without patrimonial linkage have in common that they start from the system of independent cooperative companies that wish to maintain their legal personality, but want to start a joint project, for which they create other companies or develop a collaborative framework for the putting in common of certain interest businesses. With regard to the concentration process with linkage assets, are included in this category the merger and demerger in various forms. In this type of integration, it will produce the loss of the legal personality of some or all of the companies that participate in the operation. And for last, the European Cooperative Society can be used both as a means of concentration linking asset and non-linkage asset. Cooperative integration. Demerger. Demerger is that process for which two or more companies that are terminated, all of them or few, are integrated into one single company by the transmission in block of its assets and the incorporation of the member to the society resulting, which can be of new creation or one of the companies that merge. The merger has had limited use in the area of cooperative until recently, which has dominated the constitution of second-degree cooperative. However, it is one of the structural modification procedures most widely used in recent years, and the prognosis is to go on increasing. The European Cooperative Society. The European Cooperative Society is foreseen in the Regulation number 1435 of 2003 of the Council of 22 of July of 2003. To regulate the particularities of this figure when it is domiciled in Spain, Law 3 of 2011 of 4 March and the Law 31 of 2006 of 18 of October on implication of the worker were approved. The complexity of the fund system is one of the major problems and disadvantages of this figure. It is one of the companies mutualistic made to meet the needs of its members or the development of their economic or social activities, and can operate with third parties if the values allow it. It is based on the cooperative principle of democratic member control, voluntary and open membership, member economic participation, etc. Among its features is having a variable capital, a minimum capital, and its members respond limited of the social debt, although the value may provide otherwise. To the extent that among its forms of incorporation, the society can be constituted by cooperative or other legal entities, thus resulting in the European Cooperative Society being a second-degree cooperative, or that the society is constituted by merging two or more cooperatives from different member states, it is understood that European Cooperative Society can be included within the phenomena of business concentration, having a cross-border nature, as its regulation requires the concurrence of members or companies from different European Union member states. The cooperative of second or further degree. Second high-level cooperative societies are those which group together at least two cooperative societies of the next lower level for the fulfillment and development of common economic objectives. The second and further degree cooperative has been the essential instrument of economic integration for the Spanish cooperative. Second-degree cooperatives have certain advantage over the other integration formulas. It makes it possible to concentrate and complete the commercial offer of the products produced by the member cooperatives. Joint purchases of different types of supplies and inputs can be channeled. New services or new areas of business can be initiated. Processes and management tools can be unified, lower administration costs, etc., which will have an impact on improving the management of the integrated companies. Access to greater financing, etc. What is more, the success of using this formula is due to the fact that it allows the independence of the participating cooperative society to be preserved. It is simply to operate, and its legal regime is very similar to that of the first-degree cooperative. It involves a lower level of commitment. It is flexible. It is regulated in all cooperative laws. It allows cooperative principles to be respected, etc. Cooperative groups. The corporate group is a company organization technique with little regulation. Company groups can be formed for a variety of reasons, economic, financial, or managerial. Their main characteristics are the absence of legal personality, the legal, not economic, independence and autonomy of the companies that make up the group and their structure through the unitary management exercised by the parent company. Groups can be classified according to many factors, but the main classification is between subordinate groups and coordinate groups. Subordination groups have a hierarchical structure of dependence, where the dominant company exercises the management of the group because it has taken control by means of different corporate techniques. The principle of democratic member control and autonomy and independence make it difficult for a cooperative to participate in a subordinate group as a dominated company. However, the reverse situation is possible, for example, where the dominant company is a cooperative and the subordinaries are non-cooperative companies. On the other hand, in the improper cooperative group, the unitary management is the result of an agreement between the grouped companies and is not the result of the imposition of one company on another, with the entities that make up the group themselves deciding jointly how the group is to operate. In this group model, its members, the majority of which must be cooperative societies, are organized on an equal footing, operating on the basis of the principle of coordination. The management of the group can be achieved through the constitution of a body or a company to which the exercise of management is attributed or through the creation of other links. A cooperative group is made up of several cooperative societies, in which there is a group head that exercises power or issues binding instruction to the cooperative grouped together, and entails a unity of decision-making within the scope of this power. The entities forming the peer group must give their consent to the general policy of the peer group and may oppose if it does not suit their interests. The appropriate legal instrument to form a group by coordination is the organizational contract, the adoption of such an agreement being the exclusive competence of the General Assemblies. Other forms of economic collaboration. The cooperative laws provide for the other forms of economic collaboration with lesser links. Specifically, cooperatives may set up companies, grouping, consortia, and unions among themselves or with other natural or legal persons, public or private, and enter into agreement or arrangement for the better fulfillment of the corporate purposes or for the defense of their interests. These unions may be of a temporary or lasting nature. Similarly, cooperative society may hold share if any of the aforementioned entities in order to better fulfill, develop, or guarantee their corporate purpose, without detracting from their cooperative nature. The cooperative law seeks to encourage relations between cooperative societies and other legal forms by considering as cooperative result the income from the cooperative investment in other types of company when they carry out activities that are preparatory, complementary, or subordinate to those of the cooperative itself. Under intercorporation agreements, the cooperative and its members may carry out supply operations, deliveries of products or services in the other cooperatives signing the agreement with the same consideration as cooperative operation with the members themselves. This agreement make it possible to extend the operational capacity of cooperatives to be able to act economically with non-members. Cooperative associationism. Cooperative associationism refers to a legally organized movement for the defense and promotion of interests, manifesting itself in the form of unions, federations, and confederations of cooperatives. It corresponds to the phenomenon of representative integration. Cooperatives may associate freely and voluntarily in unions, federations, and confederations for the defense and promotion of their interests. In general, they represent the different cooperative sectors of which they are composed, although they may have many other functions. In order to fulfill this function, the legal system may endow unions, federations, and confederations with legal personality, if they meet certain requirements established in the cooperative law. Thank you very much for watching our videos. We hope you found them useful.